Okay, I'm back. We've got a little bit of housekeeping to do, and as others are coming on, so I'm going to go ahead because we've got a pretty good bit of information and we try to limit this to an hour. So I'm going to get us started. Again, welcome to everyone around the world. My name is Gene King. I'm Senior Managing Director of Sequence Holdings, which is an investment banking firm in Charleston, South Carolina, but I'm also the current chairman of the Brazilian American Chamber of Commerce Southeast out of Atlanta, Georgia. So I'm the chairman of the board there. I'll be moderating today. I'd like to welcome everyone back who has been here and been with us since the very beginning of this 5-part series. Today, we have InvestAmerica, David Hirsch and Partners, and again, the Brazilian American Chamber of Commerce. And this is our last webinar of a 5-part series. And today, what we're going to be talking about is how to choose a project, the business side of the project, and the investment according to the visa that fits best for you that are interested and your family when it pertains to an E-2, an EB-5, and or an EB-1C. So I will wait for our esteemed panelists to get involved in all those things because I get excited about them. A little bit of housekeeping before we get started. First, if for any reason someone can't hear me, please hit the chat button, question button, let us know. I'm kind of reading a little bit from a script, so I'm going back and forth into the webinar to see what's going on. So I just want to make sure everyone hears me. We have panelists, we have attendees, there are options there. I'd like to advise everyone that this event is being recorded and it is being broadcast live in Facebook. I think our producer has placed that Facebook link in the chat section. So if you'd like to go there, pick that link up, forward that to anyone to see this being recorded live. That'd be a cool thing. Please know that all questions should be submitted through the Q&A button at the bottom of your screen. We'll answer everything we possibly can. And if for some reason we can't get to an answer, we will get back to you after the webinar. We have the capabilities of answering in English, Portuguese, Mandarin, Spanish. And if you happen to speak a language that we don't have, just go ahead and ask the question and we'll figure out how to get the answer. So we will get back to you. If we run out of time, again, we will get back to you with any questions. So I'm going to go ahead and continue. We've got people still continuing to come in, but let us move on. Great program today, again, and I'm proud to say, being chairman of the Brazilian American Chamber of Commerce Southeast, it's being hosted by the Chamber, but also by InvestAmerica, which is an immigration consulting firm, and in partnership with David Hirsch and Partners, LLP, an international immigration law firm. So our discussion today is going to be you wouldn't be on the webinar if you weren't interested. That's the bottom line. This is our 5th webinar. We're going to be talking today about E-2 and the investor visa, the EB-5, EB-1C green card process as a permanent process for residency in the United States. Thinking of some topics here, I'm kind of looking at my script, but really we're going to be more involved today, a little different than we have in the past for those that have participated from the past, in more of like a roundtable discussion. So we'll have questions, we'll have answers. We're just really here today to help those that are interested figure out, do I want to buy a business in the United States? Do I want to participate in a transaction? Is it going to be involved through a visa? So those are really the roundtable discussions that we'll have today, and we'll get you through it through whatever questions you may have. So I need the slide now that really is going to show the panelists that we're going to talk about today. Let me click over to that and make sure that we're on track. There we go. So I'd like to ask, if you would, each of the panelists if you would introduce yourself, clearly state your name, your company, position and responsibilities and experience within the immigration industry. And you know what, let's just get it started with InvestAmerica. Mike Zennick with InvestAmerica. Would you mind introducing yourself so everybody sees and knows who you are?
Thank you, Gene. My name is Mike Zennick. I'm the CEO and president of InvestAmerica. As Gene said, we are an immigration consulting firm. We are affiliated with a FINRA securities broker dealer called Sequence Financial Specialists that helps us to promote the securities that we sell on the EB-5 side, as well as do other sort of investment related activities and brokerage activities. InvestAmerica was founded in 2012, and I had been doing immigration consulting work for investment for a couple of years before that. And over our now almost 9-year history, we have worked with over 300 families from all over the world, 22 countries, and have successfully navigated that for all of those families. So far, 100% approval rate on our I-526 and I-829 petitions, and a good portion of our initial investors that have been in investments for over 6 or 7 years have received their full return of capital. So we are proud of that, and we'll get into a little bit later why we feel we've been successful on that side. We work with families. We work in conjunction with the immigration attorneys, like David Herson and Partners, to help each family decide which path is best for them, and then help them along that immigration journey.
Thank you, Mike. I couldn't have done that better myself. David Herson and Evelyn Hahn from David Herson Partners, would you mind introducing yourselves and letting these folks know who you are individually?
Hi, everyone. I'm David Herson, co-manager of David Herson and Partners LLP, and Evelyn, who will speak in a moment, is my co-manager and co-managing partner. We are a law firm doing only immigration work. Our leaning is towards the business and investment related immigration work. And we have been doing this out of California since 1980. So we've been around a while. We've seen it all, and we know what to do and when to do it. Just a minor housekeeping type point. You will be given a lot of information and have been through these 5 episodes. And I just want to point out that this is just the top of the iceberg. We will be available to get much more in-depth information as we go forward if you have that interest. And so don't hesitate to reach out and contact us. So with that, I'll pass to Evelyn. Thank you, Evelyn.
All right. Hello, everyone. Thank you for joining us today. And my name is Evelyn Hahn. I'm a co-managing partner at David Herson and Partners, the leading immigration law firm in the U.S. in the areas of investment and business immigration. I'm a UCLA undergrad and Chapman Law alum, selected as a rising star by Super Lawyer since 2017, and a verified EB-5 specialist by the EB-5 Investor magazine. And I have more than a decade of experience practicing immigration law, mainly focusing on investment and business immigration. I really thank InvestAmerica and Brazilian American Chamber of Commerce Southeast for hosting and inviting us to this great webinar event. Today we have a lot of topics to cover, so hopefully we can have enough time to discuss all the topics and answer all the questions you might have today. So thank you again for joining us.
Thanks, Evelyn, very much. You know, all these great webinars take a lot of people, production, behind the scenes. We've got some folks here that will be working in the background that are just really team experts. But most importantly for all of you, they speak Mandarin, they speak Portuguese. Of course, we speak English, we have Spanish. Please do not hesitate to ask questions. Do not be shy. Hit the Q&A button. They're going to be getting back. That's their job on this webinar today, is to help answer questions. There are 3 of them, Marcella, Patty, and Mila. So I'm going to ask you folks to kind of unmute yourselves and turn your cameras on. And Mila, maybe you can get it started, and Marcella and Patty, y'all can follow up and just kind of introduce yourselves so they know who's in the background helping to make this all happen.
Oh, hello, everybody. Thank you, Jean. Thank you, David and Evelyn and everybody here today. My name is Mila Diolano. I work with InvestAmerica. I'm the Global Development Coordinator. I'll be here in the background just helping out with Portuguese and Spanish. So if you have any questions or any consultation that you want to do in Portuguese and Spanish, I'll be here. And I hope you enjoy our event today.
Hi, everyone. My name is Marcela, and I work as a Director of Development for the Latin America here at DHP. So I'm also going to be available if you have any questions in Portuguese or Spanish, and I hope you enjoy this event.
Hi, everyone. My name is Patty Wang. I'll make an intro in Chinese, just in case if we have any Chinese investors or clients here that have questions in Chinese. 大家好，我叫 Patty， 然后我也是在 David Herson and Partners 律师事务所，然后跟他们一起工作。你们今天如果对移民然后商业投资有任何法律问题的话，想要用中文来问，我可以在这边帮你们翻译，谢谢。
Thank you, Patty. Did you end with thank you very much?
Yes. Thank you.
Okay, so now that we know the team that's behind the scenes and the team that's in the front of the scenes and we've got everything going, let's kind of move ahead. It's time to get some presentations started. So David and Evelyn, we got a little presentation process going here, and I'd like for you two, if you would, to kind of get us cranked up to lead us into this webinar so we can round up this 5th webinar series in an outstanding event.
Okay, Evelyn, I think you're to begin on this.
Yes, so we're gonna, so here, David Herson and I will go over some of the topics that we already covered in the previous episodes, but we're gonna quickly go over some of the important takeaways, and then hopefully we'll have enough time for the roundtable. Next slide, please. Next slide, please. So we covered E-2 visa in the past episodes, and I'm just going to very briefly go over the main takeaway. So E-2 visa is for an investor from a country that has an E-2 treaty with the United States. Here, the E-2 investor can be an individual, but also can be a company. So if the E-2 investor is a company, then we look at the ownership of the company and see if more than 50% of the shareholders are foreign nationals of the E-2 treaty country. If it's individual, then we just look at the nationality of the E-2 investor. The investor must have already invested or inactively in the process of investing a substantial amount of capital in the US company to actually develop and direct the company. There's no required amount of minimum investment for E-2, and it really depends on the business type, size, and scope, but it usually ranges between $150,000 to $250,000 to be considered a substantial investment. The E-2 investor must be able to develop and direct, so the investor must have some reasonable business background, either by education or experience. The E-2 enterprise must be at least 50% owned by nationals of treaty country, like I mentioned, and the business has to be a real and operating business, preferably with employees, even though it is not required to have employees. The E-2 business cannot be a marginal business, which means that the US enterprise must have either present or future capacity to not only barely break even, but also to start generating some profits to be able to cover all the overhead costs, as well as the investor and his family, his or her family's living expenses. So therefore, if the E-2 investor is acquiring an existing company, it is really important to carefully review the company's current financials to ensure that it is generating sufficient net income to cover the investor's living expense. If it's a startup company, then the E-2 investor will give in about 5 years to develop the business to start generating profit. So it is really important to lay out and include a very realistic and practical 5-year financial and hiring projections in the E-2 business plan. Lastly, the E-2 investor must have intention to depart the US when the E-2 status ends or terminated, and must not have intention to immigrate at the time that they apply for E-2 and they enter the US in E-2 status. Next slide, please. So the qualification for E2 employee, in case the E2 investor is a company, then E2 employee who is being transferred over to the US to E2 company to work for the E2 company, they must have the same nationality as the E2 investor company. And E2 employee either must be an executive or supervisory employee or essential skilled employees with technical or specialized skills such as engineer, special chef, IT person with a unique skill set, etc. So the common misconception that a lot of people have about E2 employee visa is that they think that E2 employees must have been employed by the company abroad, like foreign parent company, for at least 1 year before they are able to transfer to the US company. But that is for L1. This is not the case for E2, and any foreign national with the same nationality of the E2 company can be sponsored by the E2 company for the E2 employee status. Next slide, please. So I'm not going to spend too much time on the procedural steps. Just main takeaway from this slide is that it is really important to note the difference between the physical copy of the E2 visa and authorized stay they can obtain when they actually enter the US. The visa, depending on the reciprocity schedule for each country, it can be up to 5-year visa, but it doesn't mean that they will be able to stay in the US every time they come into the US for 5 years. Each time they enter, they only are given 2 years authorized stay, which has to be extended every 2 years. It can be done by just traveling back and forth, international travel. Then they'll get automatic 2-year extension, or they can apply for the extension application with USCIS and obtain their 2-year extension of status. So all the procedural stuff we can go over when you have any specific questions. Like we mentioned, E2 spouse can work and E2 dependent children can attend school. It doesn't actually automatically lead to a green card. You will have to find a separate path to obtain to a green card or citizenship status. And in case they really have to renew their status with USCIS inside the US instead of traveling back and forth, especially nowadays with COVID-19, a lot of people, instead of traveling, they decide to file the actual extension application with USCIS. Then they will really have to be careful about proving their source of funds and also proving that the business is not a marginal business, which is a common issue raised by USCIS. Next slide, please. So next slide, David will go over some of the EB-5 programs and main takeaways.
Right, I'd just like to mention, I saw one of the questions come up, that what we're doing today is a very brief recap of what was done in the prior programs, and the most of this particular program will be in a roundtable format, and we will be answering questions designed internally and taking questions from the participants. So if you are hearing stuff again, it is deliberate. So let's talk about the EB-5 Immigrant Investment Program very quickly. It is an investment that allows people and their families to come to the United States by paying in $900,000 or $1.8 million into a program in the US that creates at least 10 full-time workers. Next program, next slide, please. Next slide, here we go. The direct program requires W-2 jobs with people on payroll, 35 hours a week, lawfully entitled to work in the US, and it's advisable that they all be E-verified, as well as the regular I-9 verification. Regional center jobs, however, can be indirect or induced and created through economic analysis, and so therefore there is not necessarily an actual headcount. The job creation has to be done within a period of 2.5 years from the approval of the first stage form I-526. However, in practice, it even takes a lot longer for you to have to prove that the jobs have been created. Next slide, please. Source of funds. This is absolutely critical to the EB-5 program, and this is where immigration catches most people out because they can't prove every last dime that's coming into the program. So the funds must be lawfully obtained. It can be from multiple sources, and you have to prove the actual source and flow of the funds. The funds can come from outside the US or inside of the US. But as I said, it has to be lawful. For example, if somebody is in the US illegally and earns money, immigration has taken a position that that money is not lawful. The monies can come from savings, 401, stock options, income, loan, gifts, inheritances. You think about it, as long as you can prove that its original source was lawful. So then we go on to the path of funds. As I mentioned earlier, this has to be completely traceable and documented. Next slide, please. The comparison basically between the new enterprise or the direct investment and the regional center are basically the investment type and location. There's a lot of flexibility in the new program. To achieve the $500,000 level, you still would have to be in a targeted employment area. Sorry, the 900,000 level, you still have to be in a targeted employment area. The USCIS approves certain specific industries and locations when you have a regional center, and there's certain restrictions and limitations on the actual approval by the government. The job creation, as mentioned earlier, is direct on payroll for the new enterprise or the direct investment. And for the regional center, you can use a combination of direct hires and the indirect and induced hires based on economic matrices. Management, basically the management is the same as long as the individual investor has the right to manage and direct certain aspects of the business and has a say in it. They do not have to be in day-to-day operation. However, with the new enterprise or the direct investment, it is usual that the investor is actually involved on a day-to-day basis. The processing times are a little longer than the regional center programs. However, the regional center programs are now taking around 2 years, so it's not something that comes through quickly. We're being promised a lot more efficient service, and with the new administration, we're all very hopeful. In terms of residence, the individual should live relatively close to the project so they can attend to the business. And as far as the regional center is concerned, actual location of residence is not that critical. Next slide, please. The EB-1C program. Evelyn, you're taking the first two, is that right?
Yes, I will. So yeah, I'll just briefly go over, recap. So EB-1C, like we mentioned before, is a green card petition that allows the US company to sponsor for its foreign managers or executive employees green card. So the foreign employee must have worked for the foreign company for at least 1 year before being transferred to the US subsidiary, parent, branch, or affiliate office. And the US company must have done business at least 1 year and have strong financials to cover the foreign employees' offered green card salary, which usually ranges between $80,000 to $120K, and also offer the foreign employees the same or similar managerial or executive position to undertake in the US. Next slide, please. So this is the EB-1C Green Card Bridge. This bridge demonstrates the process of EB-1C. The foreign national with at least 1 year of managerial or executive experience with the foreign company can be transferred over to the US subsidiary, branch, parent, affiliate office to undertake the same or similar executive or managerial role. And then the bridge between the two companies must be sustained throughout the process, which means that both foreign and US companies must maintain its operations throughout the EB-1C employee's green card process, and even after his green card is approved for at least 6 months to 1 year. Next slide, please. The procedural steps and other notes, you file the form I-140 petition, which will help you. And depending on your situation, you can even concurrently adjust your status from your already non-immigrant visa status that is already approved to a green card status by filing the form called I-45 together with I-140. Depending on processing time is usually between 8 to 12 months, but depending on the office, USCIS office capacity, it may be processed quicker than that. Nowadays, surprisingly, USCIS is processing EB-1C green card within less than 2 to 3 months, but we don't think this is a pattern, consistent pattern. But luckily, we've seen fast approvals even on EB-1C green card. And you and your spouse and dependent minor children under 21 can also obtain permanent green card status and can obtain citizenship after 5 years. Next slide, please. So David will go over the business requirements and rest of the slides and wrap up, and we'll prepare for the roundtable.
Right, somewhere along the line, you'll see a mention of L1. L1 is the non-immigrant version of the EB-1C that allows multinational managers and executives to transfer to the US. And this can come through very quickly and as a temporary non-immigrant visa, used often as a bridge towards waiting for qualifying for the EB-1C green card under the same program. So to achieve the green card in the US entity must be operating for at least 1 year and be viable. Often we prefer to use an equity purchase model whereby the new entity buys an existing business and then we can process it earlier than waiting the 1 year for a new startup business. Ideally, there are 20 to 30 employees on payroll, can be less under certain circumstances, and you have to provide the various government tax returns, payroll tax returns, to be able to establish the numbers of employees, their positions, and their wage. You can't call somebody a general manager and then pay them minimum wage. Immigration picks up on this and challenges it. You will need to show that the company is able to demonstrate its ability to pay the offered wage to the incoming green card applicant. Next slide, please. Okay, so over to you, Jean. Thank you.
Thank you.
Excellent job, both of you. Lots of information here. And, you know, it's kind of like a fire hose, so much information. So if you'd like a copy of the presentation, you know, let us know. It's a tremendous amount of work that's been put into all of this. So Evelyn and David, thank you. We're going to move forward now to the roundtable discussion, and we've got a few prepared questions. Again, I am looking kind of at a screen, so please somebody just interrupt if there's a question out there that needs to be answered so I'll know. Again, we have multiple languages here that you can ask the questions. Kind of going to jump right into some questions here, and I'm going to stick with David and Evelyn, if y'all don't mind, and being that we've just gone through the EB-5, E-2, EB-1C. EB-5, I'm just going to talk about it for a second. What in your opinion is really important about the business plan of an EB-5 transaction, the economist's report that can be so vast, and the securities offering documents? What are your feelings about that?
Okay, these are critical documents to an application. The business plan has to be a comprehensive business plan as defined under certain case law. And if you don't meet that standard, then immigration will not approve the case. However, the business plan can be reduced in its complexity if you have a business that's existing and has already hired the right number of employees. The economist report, where you're working with a targeted employment area or otherwise, and you need to show the indirect employment, is critical as well, because if you can't prove the number of employees, you don't meet an essential requirement of the particular application, and therefore the case will also fail. What was the third one, Jean? I missed that.
Securities offering documents.
Okay. These are generally prepared by securities lawyers who have the skills in preparing such documents to meet SEC requirements. However, they require a very careful due diligence by immigration lawyers who need to look at them. And all in all, they must be fully compliant with the EB-5 side of the house, because, example, if you have some guaranteed buyback at the end of the deal, the case will fail. And there are various other issues along the way. I call it a minefield. If you don't carefully take out all the mines as you go forward, you will not be able to get your case approved. Thank you, Gene.
Yeah, we're doing okay with time. I've got, unless some questions come in, I got a few more things. I'm gonna jump to a question. How about the terms of the investment, an EB-5 investment? What are the terms? What am I getting into?
Evelyn, you want to pick it up?
Yeah, so can you guys hear me?
Yes.
Yes.
Yeah, so the terms of investment is different than immigration requirements. So terms of investment are laid out and memorialized in the offering documents, PPN, and securities offering documents. And that terms of investment may differ, may be different from the EB-5 requirements that oftentimes people get confused and they think that because EB-5 policy or regulation changes, then terms of investment can also change in line with EB-5 policies and regulations, which is not the case. Therefore, it's really important to carefully review the terms of investment memorialized in the securities documentation with the expert. And also, of course, it is really important to make sure that EB-5 regulations are in compliance, but it is also really important to review the terms of investment with the expert, including the securities attorneys and due diligence person, to make sure that the investor fully understands what they're agreeing to in terms of terms of investment. So it can be very different. It can vary depending on each project. And maybe Mike can chime in and explain.
I could just jump in on that if I may. I
Sure.
think that part of this question related to the time of the investment, how long the investment needs to be in the project.
Okay.
So that's part of the term. Your answer was correct, but I think there's a bit extra to it. And that is that you need to be invested up front, or you can prove that you will invest in a very short time. You're in the course of investment, and all of these monies need to be proved as legal and lawful going in, and the future money to go in. Then the money has to remain in the project for the duration until such time as the 2-year conditional residence has passed, all the jobs have been created, and the removal of condition application under the form I-829 has been filed. Now, this can stretch for a very long time based on processing times of immigration. So a couple of years to get the first stage approved, another year or so to get the immigrant visa approved either by adjustment or through consular. A potential wait for years for a visa number, which will delay the last 2 that I mentioned. And then finally, the end of the 2 years in that 3-month window between 21 and 24 months before the 2-year conditional residence expires. So you can see that this can be short. In the old days, a couple of years back, this was much quicker because you could literally time it and you knew within months of when your conditional residence would become permanent and full. Thank you, Jean.
Just to chime in to David's point, it is called sustainment period, where investment amount can be returned after the I-829 is filed, but before USCIS made it clear, it used to be that final adjudication of I-829, and when the investor signed that initial agreement saying that they can only receive the funds back after I-829 is finally adjudicated, just because EB-5 policy has changed doesn't mean that they can go back and ask the project to return the capital when they file I-829 petition. So it is really important that important for the investors to understand that they are actually also contractually obligated to go with the original agreement, terms of the agreement.
Boy, I'm gonna bring Mike Zenick, I'm gonna put you a little bit on the spot, and I'm gonna bring up something that I hate to talk about, but sometimes things don't work. Can you tell us, being that we've got kind of a perfect record, so I don't want to break that, but can you tell us what happens if a project fails or the I-526 is denied?
Well, there's trouble. So
David, I'll let you off on that. I thought that was nice. I transitioned.
yeah, no, well, I appreciate that. You are correct. While we don't have experience with that, we do have experience with dealing with RFEs, with immigration attorneys, helping to, get those answered. So let me talk a little bit about that first, and certainly David or Evelyn, please chime in. It's all the things that David and Evelyn just mentioned, but they're not they're not correct, there's other things that are not structured properly or set up properly, whether it's the business plan or the terms of the offering, USCIS, and sometimes just arbitrarily, will send requests for evidence that requires the investor to respond within a certain period of time to correct those things or to further explain those things that typically they work with. And if it's project related, then they'll work with the project that they invested in and their immigration counsel, as well as the investor's immigration counsel, to prepare a proper response. If it's investor related, then there may be a bigger issue as it relates to source of funds either being inadequate or being able to not be able to connect all the dots from when the investment or the proceeds of the investment originally were generated to the point that it was actually invested in the project. Because we got close to a denial on a couple, really you have multiple opportunities. Again, David and Evelyn can go into more detail to correct the wrong before you're officially denied. If you're denied, then basically it means that the investment that you made doesn't qualify for EB-5, and your petition will be revoked, and you can't apply under that particular project. Or if it's a source of funds issue, maybe a specific issue for you for the individual investor that may prevent them from applying in the future. If the project fails, that depends on when it fails. If it fails before the jobs are created, then that's going to be problematic for the investor as well. Their I-526 petition will be, or actually at that point they may have been approved, but their I-29 petition will not be able to be fulfilled or filled out. So their conditional residency will never convert to permanent residency. And those are things, again, there's lots of steps that go along before the final denial, but typically that's how it works. If it fails after the jobs are created, then it may just mean a loss of investment, which obviously $900,000 is a big loss. Sometimes there's partial loss. You get some recovery. That's why it's really important, we'll talk about in a few minutes, to do due diligence and focus on the structure as well as the terms of a project.
Hey, we're talking about risk. I'm sorry, Evelyn or David, did y'all have any comments about that?
Yeah, it's well known that the USCIS never makes a mistake. However, we sue them and we win. So perhaps they do make some mistakes. A lot of what they see is their perception or directed from administration is to find reasons for failure of these cases, even if they don't really exist. The courts, fortunately, have come to our aid on many occasions. So we've won every case we filed against immigration, or it's been settled in the favor of our clients. So bear in mind that a no from immigration is not necessarily a total, complete no. Thank you.
Boy, that's good. Yeah. Hey, Mike, while we're in the risk assessment access, I'll ask you, but Evelyn or David, please. What are the key risk factors to evaluate when you're trying to consider an EB-5 investment? Like, is there something that's more important than something else when you're really considering risk? And risk being, can I invest and get my money back, or am I going to get everything done so I have permanent green card? So what are the key risk factors? And I know that's a long discussion and we got about 20 minutes left, but I'm laying it out there.
Sure. Well, I'm going to leave the immigration risk answer to David and Evelyn because there's lots to talk about on that side. Our focus is the investment side of it and the project side of it. Does the project, the management team, the ownership team, the structure of the project, how much EB-5 capital is in the structure versus other capital? Where do the EB-5 investors sit in that waterfall of priority? There's lots of things to consider, and I think obviously one thing that everybody needs to understand, as it's a requirement of the program, and it's also inherent in most private placements, which EB-5 offerings qualify for, is that the investment has to be 100% at risk. So the risk is there from the beginning. But that doesn't necessarily mean that people have to invest in a risky project or a risky investment. So, risks are, have the people that you're investing, the project you're investing in, have they done this before? Have they, executed a project like this before successfully? What kind of track record do they have? What kind of backgrounds do they have? We do a lot of due diligence to make sure that the backgrounds of these people are not onerous and are not unscrupulous. A lot of people Google EB-5 and they see all the bad stuff because that's what kind of comes up first when you do a Google search of all the bad projects that have been, in the industry, fraudulent use of funds, lots of things, investment in projects that actually didn't exist, lots of things like that. So it's really important to do the due diligence. But I would say for a normal average project, looking at capital structure, making sure that the project is fully financed, meaning that the project will be built, or at least will be funded to be built. Then looking at construction risk, is it going to be in an area that is going to have any issues related to getting the project or the facility built? Is it going to be, building a new hotel in an area where occupancy is very low? Obviously, sort of hard to judge that in COVID times, but in normal times, that's something that you would look at there. So looking at the market study, making sure that the demand for whatever facility is being funded is going to be there. That's a big risk. So construction risk, which ultimately turns into job creation risk. So that's those things go typically hand in hand with most EB-5 projects. So I would say capital structure, how much money is being put in by the EB-5 compared to everybody else, where that EB-5 money sits. Is it ahead of the developer and any other common equity? And typically we like to focus on projects that are at least at the top of either at the top of the list or right below the senior debt. That way, you have a high likelihood of return of some capital should something go wrong. And then also, there's again lots of other structural things to talk about, but those are what I see as the key risk from a business side.
Thanks, Mike. David, you and we got about 15 minutes left, so we're okay. We still got E2 to talk about, EB-1C, but y'all want to hit on some of the risks that are going to take place in the transactional side from an immigration standpoint?
Yeah, first of all, Mike's points on due diligence on the project are spot on. I would say that either simultaneously or concurrently or immediately after, your next area of due diligence is having all of the documents checked by Immigration Counsel who know what they're doing. Unfortunately, there are some out there who are looking for fees without the knowledge, and this can lead you to potentially a substantial loss. So you look to see that everything is in compliance with this myriad of rules that immigration come up with and keep coming up with. So everything needs to be kept up to date and to follow all of the rules. I don't know if Evelyn wants to highlight a few of them, but that's sort of a general picture. You must do your immigration due diligence as well as your project due diligence.
Yeah, I totally agree and echo everything that David and Mike just mentioned. And also, in general, I think it is really important to work with a credible, developers and people who know how EB-5 industry and regulations and all these policy changes work. And every time any kind of changes happen, then project should be aware of those changes and be able to update those project documents, not just trying to make sure that everything initial project documentations are in compliance with everything, business plan requirements, economic report requirements, and securities regulation requirements. In addition to all the EB-5 regulations, it is really important to be mindful of all the constant changes that are happening in the EB-5 industry. And also when the project fails, then whether that project developers are able to sort of make up for all the shortfalls or to be able to complete the project with their ability, financial ability and situations. And if not, then can they help at least the EB-5 investors to obtain their green card by meeting those conditions for I-2-9? For example, for the company that files for bankruptcy, it is really important to at least be able to keep the new commercial enterprise, which accept and receive the EB-5 capital, to be able to at least demonstrate to USCIS that all the job creation have been met, and also the NCE, the actual commercial enterprise, have been maintained. So here's just a few examples, but it is really important to make sure to conduct very careful due diligence to be able to make sure that they work with credible people who know the EB-5 industry.
That's perfect. I'm going to shift everybody's thinking here for a few minutes. Let's go to E2, the E2 visa process. Evelyn, can you give us an answer to what amount of money is regarded when y'all were talking about earlier the E2 process? What is substantial investment? What is somebody looking at for E2?
Yeah, so just unlike EB-5, there's no required minimum investment amount for E2. But like I mentioned, we typically see that it ranges between $150,000 to $250,000. But it is really up to the business type, scope, and the style of the business. So for example, if you're looking at some kind of consulting business or e-commerce company, which connects manufacturers with the consumers, then they don't really need a warehouse, right? Because it's not like they're manufacturing the products. So those type of companies can actually function and operate using their virtual office, but and yet can also generate sufficient income to overcome the marginality requirement. But it really depends on the type of business. And with that kind of business, maybe it doesn't really need $150,000 to $250,000 initial capital investment. And we can even make a case with less than 100,000, but it really depends on the type of case.
You're kind of on a roll right now, Evelyn. What makes can a passive investment be utilized here?
You cannot. Like I mentioned, the investor needs to be able to direct and develop the company. So they can't just sit and rely on this management company or team to run and operate. They can have a management team or subordinate general manager or people who run the business for them, but they still have to get involved in developing and directing the business. So they can't just be a passive investor.
Mike, a question for you. In an E2 environment, should the investors look beyond the company they're looking at on the initial approval process?
Absolutely. Obviously the most of the marketing that's out there and talking about E2 is getting a business that is conducive for E2 approval. And while we do focus on that, and that's very important, we also are focusing on, can this be a sustainable business? Because obviously the goal for most E2 investors is to maintain this presence in the United States through this business for many years. So there are requirements for renewal of the visa, depending on where they're from. Every 1 to 5 years, there's other categories in there too, but essentially they're looked at periodically. So we want to make sure that the businesses that are being invested in are profitable, either from an existing business that they might be buying that has a history of profitability, and then also if it's a franchise, making sure that the revenue model of that franchise is proven across multiple different units that have already been operating in the United States. And it's also looking at the geography, where somebody want to live. If they want a business that is highly competitive in a particular area, while it may get approved for E2, you have to be really careful that you're going to be in business when USCIS reviews your case for renewal. So it's really important to find businesses that are sustainable, businesses that can pass the renewal process when USCIS comes to look at it periodically.
Thank you. We've got about 8 minutes left, so that gives us some time. I'm going to kind of move to, unless somebody jumps up with a question, to the L1 EB1C pathway. David, I just got to get back to you because I feel like you're sitting out there all alone with no questions. So I'm going to put one out to you.
Hey, thank you.
foreign company, okay, L1, EB-1C, must the foreign company continue to operate and remain viable until all immigration processing for the green card is being completed if you've purchased a business in the EB-1C?
Well, I refer you back to Evelyn's part of the program where she showed you that bridge. Now, if the foreign company does not continue, that bridge will fall apart and the case will fail. So the answer to the question is yes, you have to have both the US and the foreign company continuing and maintaining a level of viability until the full green card process is completed. If you don't do that, you can land up with the refusal to complete the green card for that individual.
So you can't hire an engineering firm to come in and rebuild the bridge, it's pretty much gone, huh?
Well, if you get it in time before immigration finds it's broken, maybe you'll be okay.
Oh my God. What happens? Here's another one, maybe Evelyn. What happens if the qualifying relation of the foreign company and the US company changes?
So it really depends on the timing of the green card process. If that qualifying relationship between the foreign company and then the US company breaks during the process, while the case is in process, then we have a problem. It will likely negatively impact the case, and even we might see a denial depending on the situation. But if it's after the EB-1C green card is approved, the actual final green card for that applicant is approved, then depending on the timing, if it's less than 6 months, then when that applicant, the beneficiary who received the EB-1C green card through this sponsorship, later on obtain naturalization, the citizenship through naturalization, then this question as to why you start working for this EB-1C company, the green card sponsorship company, within less than 6 months, that question may come up, and that person must have some sufficient reasonable explanations to explain why. So depending on the situation, it can be problematic or it can be an issue that can be overcome.
Okay. Mike, flowing along with this, so EB-5, EB-1C, what's a typical size business that one should really realistically expect to look at, and what do you think they should pay for a qualifying business, or is that just all over the chart and there is no norm?
Well, it is all over the chart in the sense that it really depends on the business. If it's an existing business, then what is that existing business? How much? What's the operating profits of that existing business? And what's the multiple of value of that particular business? So really kind of depends on what you're looking for. But it's certainly going to be in most cases, if not all cases, more substantial than say an E2 business, in the sense that you're going to need those managerial business that's got those different managerial levels. You're going to have a certain number of employees. Again, there's no specific number, but when you start talking about companies that are structured that way, that look like that, and you want it to be a viable business, so you want to buy something on the cheap, it's not going to probably happen. And even if it's going to be kind of a new company that gets set up and then you wait for the year, it's still going to need to be a substantial investment. And I think the other thing to consider here too is that if there's going to need to be, there may be continual capital that needs to be put into the business. So the initial acquisition price might be one thing, but just imagine if you're buying a company that's got all those different levels, different employees, profitability, you're probably going to be paying at least, I would say, $750,000 to $1, $2, $3 million, depending on the business, and then you're going to be required to keep the business sustainable. So if it's not putting off enough profit, or if you need to contribute capital into the business to correct something here or there, there's always that responsibility of the investor, whoever's going to be leading that charge, to be on the hook for that extra money. So it's got to be somebody that's well capitalized or well capitalized via the business that's supporting them, to make sure that business is large enough And it's not a $150,000 investment. It's substantially more.
Gotcha. All right, I think we've got it's 58 on the hour. I'm going to ask David and Evelyn one last question here because it interests me as well. So I've purchased this business. Can there be more than one manager or executive in the United States? And what are the basic requirements in an EB-1C process when it comes to management of the business? And we got a couple of minutes, so I don't let that pressure your answer.
Will I take it, Evelyn?
Yeah, sure.
Okay. You can have more than one manager. You can have more than one executive, but this couldn't be in slightly bigger than a mom and pop operation. The operation has to be sufficiently extensive to require this kind of management level in its basic structure. So if you've got a multi corporate group with different entities and factories and sales outlets all over the country, surely you can have managers in each of them. But if you try and push 3 managers and 1 executive into a Subway sandwich store, you're not going to get off the ground.
Gotcha. Whomever is controlling the video here, can y'all put up the final slide? Because you folks, Evelyn, Mike, David, y'all done a great job, and I'm going to kind of start the wind down process here. So literally, our contact information is on the screen, so that's important. I kind of most importantly want to thank David, you and Evelyn and your partners, and Mike Zinnick and our team with InvestAmerica and Brazilian American Chamber of Commerce, Southeast, for sponsoring this and pulling this together. These are 5 webinars that we have put together. They're all available. We've got a YouTube site. Please reach out if you want access to any of these webinars to review them and see them. We're on LinkedIn, we're on Facebook, we're on Instagram. We're all over the place. We're all over the world. We want to do business. We want to help. So I can't thank each and every one of you for being a part of this, for making this happen, for bringing all this information to everybody. I thank all of you very much for watching and participating, and just have a great year. Here we are, 2021. Lots is going to happen this year, and I thank you all for being a part of it.
Yes, thank you, everyone. Appreciate your attendance today. And if you were part of any previous webinars, thank you to David and Evelyn and Patty and Marcella and everybody at David Hurston and Partners for this great series. Looking forward to do more with your firm in the coming year. And also for everybody, for all the attendees, you will be getting an email tomorrow with a recording of this webinar that you can watch again or send to other people that might be interested, as well as a copy of the presentation, and ways to contact us for free consultations to talk about your interests and your immigration journey. Thank you again, and we appreciate your watching today.
Good morning.
Mike, thank you. Sorry, Michael, thank you. We are also grateful for having been invited in to participate. We've enjoyed it. I hope that we've given information valuable to the participants, and look forward to a new and vibrant series in the near future. Thanks, everyone.
Thank you.
Thanks, Evelyn. Thanks, David. Thanks, Mike. Thanks, Mila. Thanks, Marcella. Thanks, Patty. Great webinar. Thank you.
Thank you.
Thank you, Jean.
Bye, thank you.
Bye.
Bye-bye.